The scope of the challenge is that this law is unconstitutional. Now we are going into how we will interpret, and I don't want to observe anything in the whichever judgment is delivered, how, if the law is upheld, how it is to be. That is up to, at the time, appropriate body, whether it's a full court, whether it's a committee. We will certainly not accept, or even consider what you say. We will determine that ourselves. Yes. So let's not go into uncharted waters. Simply an attack has been launched on the Act on its basis of its constitutionality, how it will work, whether it's functional, whether it's unworkable, it may require additional input from the committee or from the full court, are matters which I don't think we want to hear even from you, because we're not asking assistance. If a problem arises in a case, it may come, we may issue you notice under Order 27 to come and please assist us on that score. So let's restrict the scope of this thing. And I think the fundamental point जो हम लोग बार बार भूल जाते हैं, वो दुनिया जो है ना, वो एक दूसरे के साथ मिल चलती है, एंटेगनिस्टिक नहीं चलती है. ये जो पार्लियामान है हमारी दुश्मन नहीं है, और यकीनन पार्लियामान हमें नहीं समझती हम उनके दुश्मन हैं. तो दोनों को साथ भी हम चला सकते हैं कि नहीं मेरा इख्तियार और तुम्हारा इख्तियार. ये दुनिया चलती है ना, उनके बड़े बड़े इश्यूज़ हैं, क्लाइमेट चेंज हैं, लोगों के हकूक़ हैं. हम इस बारीकियों में फंस गए, क्या क्या हो रहा है दुनिया में, और दुनिया आगे जा रही है और हम लोग बस इस बाहर बहसों में पड़े हुए हैं. हम एक दूसरे की कदर, हम क्यों उनको मनफी तरीके से देखें. हम कह सकते हैं हाँ आपने कानून नेगेटिव इम्प्लिकेशन दें कि आपने गलत किया. भाई शुरू तो करें इस बात से कि आपने सही किया है. हाँ इसमें कोई गैर आईनी बात है वो हम देख लेंगे, उसको यहाँ तक ख़त्म कर दें. तो इतना हमें लड़ाने की कोशिश ना करें एक इदारे को दूसरे इदारे से. मैं तो कहता हूँ, अंग्रेजी में पता नहीं उर्दू में कैसे कहेंगे, लिव एंड लेट लिव. और आप इसकी बस कॉन्स्टिट्यूशनैलिटी देखना है, बस इतनी सी बात है. अब हम वो इंटरप्रिटेशन हम लोग कैसे करेंगे, भाई हमारी मर्जी है. आप वो वक्त आएगा कर लेंगे इंटरप्रिटेशन. थोड़ी बहुत अकल समझ है, 40 साल से ज़्यादा वाबस्तगी है कानून से, कुछ ना कुछ समझ आ गई है, तो अब हर चीज़ हम लिख दें कि ये मसला आएगा तो हम यूँ करेंगे और ये मसला आएगा तो यूँ करेंगे, तो फिर तो ना कमेटी की अहमियत रही और ना वो फुल कोर्ट एडमिनिस्ट्रेटिव साइड पे उसकी अहमियत रही, क्योंकि अब फुल कोर्ट का जजमेंट आ जाएगा. फिर तो बिल्कुल आपने हमें पाबंद कर दिया और हमें स्ट्रेट जैकेट में डाल दिया. उधर हमें ना ले जाइए, आप सिर्फ फोकस रखिए आइन पे जो अटैक हुआ है.
My Lord. Grateful. My Lord, now to constitutional conventions, if I may begin my submission on that. My Lord, my respectful submission is that our Constitution in its text does not recognize any convention. It does recognize customs or usages having force of law, but not the conventions. And I say this because conventions in historical sense,
Article 8.
Article 8, Clause 2, and then Article 203C, 203B in Federal Sharia Courts is Clause C, which also uses the phrase customs or using having law. I'll come to that in due course. What are those customs or usages which have force of law? I refer to a statute of 1872. My Lord, the conventions are a feature of an unwritten constitution, which is that of the United Kingdom. It is acknowledged by the English courts that the constitution, the conventions may be, the reasons for having those conventions, acting upon those conventions may be so strong that not acting upon them might elicit response from the people. But the conventions by themselves do not abridge the Parliament's power to legislate to the contrary. And if so done, the courts cannot hold them unconstitutional. I will, there are two judgments to the contrary what I am submitting. In Al-Jihad Trust case, this court held that they do attain a status of law and are enforceable by the courts. And in Malik Asad, they go a step further and say that conventions established over a period of time have the same status as that of a constitutional provision. My Lords, and with the benefit of addressing the full court, and those judgments not having the binding effect, if I may take your lordships to the critique of the two judgments by late Justice Fazil Karim in his book titled Judicial Review of Public Actions, Second Review, Volume 1. I'll place the copies before you, lordship.
Judicial review of
Actions.
What edition is this?
My lord, this is second edition.
I think he was one of the finest writers of Pakistan law. Each book is, I've always gained a lot from reading Justice Fazil Karim's books.
Volume and
Page 95. This is volume 1, my lord, page 95. I placed photocopies of the relevant pages. Page 95.
His skill was to explain complicated things simply.
Absolutely.
95.
95 now towards the bottom, my lord. The last paragraph, but I'd start with the last, the second sentence. It was settled. Page 95, sir.
last line.
Ji, last line. 95, last line. It was settled in Federation of Pakistan versus United Sugar Mills Limited, PLD 1997, Supreme Court 397, that the expression law means positive law, that is to say, a formal pronouncement of the will of a competent lawgiver, and did not include what are mere legal precepts and theories. Next para. In sum, it appears to us that constitutional conventions are a special feature of the British unwritten constitution, and that they have no place in the written constitution of Pakistan. All the important parliamentary constitutional conventions have been written into the Constitution of Pakistan. Under that constitution, the courts recognize and enforce only what the law in the constitutional sense of the word is. Then, if we may say with great respect, Al-Jihad Trust case, PLD 1996, Supreme Court 324, and Malik Asad Ali case were the product of a period of unfortunate tension between political organs and the judicial organ of the state of Pakistan. That period evokes painful memories, and it is better to forget it. Even the judges of the Supreme Court could not remain unaffected, so much so that at the time of Malik Asad Ali case, the Supreme Court itself was a divided house. In such a polarized setting, the venerable principle of the Committee of Judges is naturally the major casualty. In our humble opinion, therefore, the decisions in those cases should be confined to them only.
Per incurium.
My lord. My lords, if my lords may kindly now turn to Article 8. And I'll just point out, walk you through the language of words, customs or usages.
Customs and usages of law have a totally different and distinct meaning.
Yes.
They've got nothing to do with constitutional law.
That's right.
They are recognized. Someone who has read, who can pick up any book of jurisprudence, and I can start with Samand on jurisprudence and go on. They explain what customs means. They explain what usages of law mean. They are absolutely clear that there is nothing to do with
There is this
constitutional
Punjab Laws Act 1872 actually, which the Punjab Laws Act 1872, which
What is that
acknowledges.
What is that to do with constitutional conventions?
No, so I'm just concluding, making my submissions and moving
Usages
on.
of law are ordinary law.
I understand.
Constitutional conventions are part of constitution.
And that's what I am submitting, that what is or had to be acknowledged by the Constitution from customs or usages, the Constitution does so. Otherwise, as some genre of what exists, the Constitution does not say that conventions will be part of the Constitution. The Constitution actually incorporates them. So whatever, as Justice Fazil Karim just says, that the written Constitution actually
But what about the
acknowledges them,
No, but
accepts
what
them,
about-
builds them into the
What
body.
Well, first of all, the fact that there are some constitutional conventions which are incorporated in the context of the Constitution, that is premised that there are constitutional conventions. In fact, there are certain articles of the Constitution which perhaps abrogate constitutional conventions. So when the Constitution has to be read, it has to be read in the context of, it is premised on there being constitutional conventions, right?
Yes.
For example, in Westminster style democracy, parliamentary democracies, the head of state has what are called reserve powers. Those are constitutional conventions. They are recognized, they are recognized, for example, in Canada, where Canada has a written constitution. They are recognized in Australia, where Australia has a written constitution. They are recognized in India, where India has a written constitution.
And they are recognized by Pakistan, where we have a written constitution.
So my point is that if you're trying to equate customs and usages of law as used in Article 8, with all due respect, how can you do that when the constitutional conventions are on a different plane? And as you have very rightly pointed out, there are two judgments of this court, now of some standing, where the different view has been taken.
Let me just proceed a little further with my submission.
But are you saying that the word convention is not used in Article 8? And then are you fortifying your submissions by contending that Malik Asad case and the Al-Jihad case may be decisions of this court, but they do not bind this court in terms of Article 189, because it's very specific. The decisions of these court are binding on all other courts.
That's right.
And not on ourselves.
That's why